Welcome to the Contract Law Lecture Series with me, Mahncke, at the University of the West Indies Faculty of Law. Today's lecture is on intention to create legal relations. Let me start by giving a brief overview of the lecture. We'll start with an introduction to the topic of intention to create legal relations. In particular, what does that term mean? Where did it come from? We'll then find that that term needs to be split into two separate areas. The social and domestic context on the one hand, and commercial and business context or commercial and business transactions on the other hand. And we'll see what all that means as we go along. And lastly, I'll give a brief conclusion and summary of the lecture. In order to demonstrate that a valid contract has indeed been formed, we of course need to show that there are four elements present. There's an offer, there's acceptance, there's consideration, and lastly, the last of these four requirements, that there is intention to create legal relations. This requirement aims to sort out cases which are not ripe for court action, and there could be a number of cases which for various reasons are not the type of cases that should be heard in court. Now there's various rationales that have been put forward for this intention to create legal relations requirement. One of the rationales is de minimis non curat lex. What that means is that the law does not concern itself with trifles. So if there's a case which the law considers to be a trifle, perhaps that is not the sort of case that should be heard before a court. And we'll look at some examples in particular in the social and domestic context, for instance, agreements between husband and wife. Another rationale that has been put forward for this requirement is the floodgates argument. The idea that if all types of agreements, including those where perhaps the parties did not have a clear intention to create legal relations, are to be heard in court, there would be too many cases, and so you'd have the floodgates. And another argument is that by having this requirement, we maintain social, family, domestic arrangements and relationships. So not every agreement that is made in those forums, say amongst family members, would be such that it would be a valid legal agreement which could be then taken to court. So perhaps the best way of putting it is that intention to create legal relations means that the parties to a contract have agreed or know that they have an understanding that if things go wrong, if there should be a dispute, then they may be sued in court. So we ask ourselves when we look at an arrangement, when we look at an agreement, not only is there offer, acceptance, and consideration, but also have the parties agreed that should things go wrong, the matter may go forward and may be heard in court. So to use an example from the book by Professor Firmston, what if two friends go out to a restaurant and they have an agreement? The agreement is that if one friend pays for dinner, the other friend will pay for the drinks. So you have offer, you have acceptance, and you have consideration. But should that be an agreement that is in fact legally binding? In other words, should the friends be deemed to have agreed that if there is a dispute, if things go wrong, that one can sue the other? Probably in that scenario, those friends would not have agreed to that. There was no such understanding, and hence there would have been no intention to create legal relations. Now there is some overlap between consideration and intention to create legal relations, and indeed in civil law systems they do not look at consideration, they only look at the intention. They only want to know whether the parties did in fact intend to create a legally binding contract. Now consideration can play a role in this because after all, if you're going to provide consideration, you probably mean to be bound by the agreement. However, as the example with the two friends who go to a restaurant shows, sometimes you can have consideration but no intention to create legal relations. So that is perfectly possible, and so it makes good sense to have the requirement of intention to create legal relations as the fourth requirement for formation of contract. Now, whether or not there is such intention is based on an objective test, so we can measure that objectively. So for instance, in Carlyle and the Carbolic Smoke Ball Company, we all recall this is the case of Mrs. Carlyle seeing an ad in the paper which had been put there by the Carbolic Smoke Ball Company, and basically the ad said, if you take these smoke balls, you will not get influenza. So that was a unilateral offer, and Mrs. Carlyle accepted the offer by buying the smoke balls and taking them, and in the end she still got ill, and hence she sued for the reward that had been mentioned in the ad. Now, one thing that is very important about this ad is that the Carbolic Smoke Ball Company actually put down a deposit with a bank in order to show their seriousness about this reward that people may get if they get ill in spite of taking the smoke balls. So by placing the money with the bank, they have showed an intention, they have showed seriousness. So this is a very, very important factual circumstance which shows that in fact the Carbolic Smoke Ball Company did intend to be bound by the contract that was formed between themselves and anyone who took the drugs and got ill. So objectively, looking at the situation, we'd have to say in Carlyle there was intention to create legal relations. However, there's also the case of Lens and Devonshire Golf Club, which involved a golf competition, and there was a prize to be won. Now, the prize was not paid out, and the question arose whether that was an intention to create legal relations on the part of the golf club when they advertised this competition. And again, just looking at the objective facts on the ground, the golf club, represented by its members, by its board, did not intend to create legal relations by way of this ad. Ultimately, when we look at the intention to create legal relations, we really need to look at it in two halves. There's the cases which involve social and domestic matters, such as arrangements between family members, arrangements between husband and wife, arrangements between friends, all that sort of thing. Those are treated in a particular way, and then the other half are arrangements between companies, arrangements between consumers and companies, so anything that falls within the commercial or the business transaction half. So those two are treated differently, and now let's have a look how exactly that works. In the social and domestic context, there is a presumption against intention to create legal relations. In other words, where a contract or an alleged contract is formed between, say, a husband and a wife, or between siblings, or between a parent and a child, the presumption says that there is no intention to create legal relations. In other words, even though you may have offer acceptance consideration, there is no contract. No contract has been formed because of this presumption. However, this presumption can be rebutted, and we will look at various examples of when and how it can be rebutted. But overall, the general rule is that there's a presumption against the intention to create legal relations. What's the case for this? Well, a very famous case, a leading case on this is Balfour and Balfour. This case involved a husband and a wife who lived in Sri Lanka. And they went back to England, which was where they originated from. And while they were in England, the wife fell ill and was not able to return with her husband to Sri Lanka. So her husband went on his own. Of course, this is 100 years ago, and travel was difficult. You had to go on a ship, and it would take a long time. So the husband agreed or promised to pay the wife a certain amount of money while she was still in England recovering. After a while, the husband stopped paying, and the wife insisted that the husband had to pay the money that he had promised. Now, in the event, the court decided that the husband did not have to pay. Now, one of the arguments, which doesn't concern us right now, is that the court did not find that the wife provided any consideration. So the husband made a promise, but the wife did not give anything in return. Okay, that aside, the court also found that since this is an arrangement between a husband and a wife, the presumption is that there is no intention to create legal relations. That means when the husband made the promise, he did not do so on an understanding that should he not pay, he could get sued in court. There was never any such intention. So husband and wife, when they have an arrangement, when they have an agreement, the presumption is that there is no intention to create legal relations, hence there is no valid contract formed between them, no legally enforceable contract. You can't go to court and sue the other. Here's how the judges put it in Balfour and Balfour. In respect of these promises, each house is a domain into which the king's writ does not seek to run, and to which his officers do not seek to be admitted. So matters which are domestic, which happen in the private lives of people, for instance, between husband and wife, or between parents and children, or between siblings, or between friends, those are matters which the court does not get involved with. So that's the basic position. That's the default position, presumption of no intention. However, there are a number of exceptions. So let's try and go through all the possible exceptions. First of all, what happens where there is a husband and a wife, but they are separated? So for that scenario, we look at the case of merit and merit. So in merit and merit, the husband had moved out and the wife remained in the house which husband and wife had shared. Now there was still some mortgage outstanding on the house, not too much. I think it was around £180. And so the husband and the wife met, not in the house, but actually in a car outside the house, to discuss what they were going to do about the mortgage. And the husband said to the wife that he would pay her £40 a week, and that the wife was going to pay off the mortgage, as well as take care of aspects to do with finalizing the mortgage once it's paid off. And that involved a lot of work, a lot of paperwork, final payments, additional payments, and so on and so forth. Now the husband made that promise, and the wife made him sign a piece of paper to that effect. After the mortgage was paid off, the husband did not want to transfer his share of the house to the wife. And he argued, or his lawyers argued, that there was no intention to create legal relations because after all they were husband and wife. The court did not agree. The court found that since they were separated, and since the husband had signed a piece of paper showing his clear intention to be bound, he was bound by his promise. Now the question of consideration also came up in this case, but the consideration is of course the wife's promise to deal with all outstanding matters to do with the mortgage. So that wasn't really a problem at all. So where we have a case of a husband and a wife, normally there's no intention to create legal relations when husband and wife enter into agreements. However, when they are separated, that intention to create legal relations does exist, so that presumption is rebutted. What about where the consideration is executed? So for this we look at the case of Petit and Petit. What happened in this case is that there was a wife and she owned the house that the wife and the husband lived in. Now, the husband had made some improvements to the house. He had done a bit of DIY in the house. So the question arose whether the husband, by improving the house, by applying his labor to the house, had acquired some interest in the house. Now, this involves some fairly complex matters of trust law, which we won't get into now. However, for our purposes, it's important that the court held that as long as the consideration is executed, that means it's already been provided, there may be legal consequences that flow from this. Now, in the event, Mr. Petit did not get the share, so it didn't apply to him, but it was at least possible, the door was open to that possibility. Let's look at how the judges phrased it. If contracts are executory, they do not give rise to any chosen action, for neither party intended that non-performance of their mutual promises should be the subject of sanctions in any court. So that's Balfour and Balfour. So if you made a promise going forward and ongoing, such as to pay a certain amount or anything like that, well, that does not give rise to any cause of action. There is no intention to be bound, no intention to create legal relations. However, and this is how the judges put it in Petit and Petit. But this is relevant to non-performance only. If spouses do perform their mutual promises, the fact that they could not have been compelled to do so while the promises were executory cannot deprive the acts done by them of all legal consequences upon proprietary rights. So, at least it opened the door, the possibility of the husband, by having executed his consideration, having acquired some legal rights. In the event he didn't, but at least there was a possibility that he might have done. Now, in Arrington and Arrington Woods, we find that where unilateral offers are made, and of course unilateral offers may be accepted by performance, there may be an exception to the general rule that there is no intention to create legal relations in the social and domestic context. What happened in that case was that there was a father, Mr. Arrington, and his son and his daughter-in-law lived in a house which he had paid for. Now, there was still a mortgage on the house, and the offer that was made by the father was that if the son and the daughter-in-law pay the mortgage for the house, they would eventually gain ownership of the house. So he would transfer the house to them once the mortgage was paid off. Now, unfortunately, the father died. At that point, the son moved out and he moved back with his mother, and the daughter-in-law remained at the house which was the subject of this mortgage. Now, the daughter-in-law continued to pay the mortgage, and eventually it was paid off, and so she claimed the ownership of the house, at least her part of it. Now, the mother, the widow, she said that she wasn't going to transfer the ownership, and one of the arguments put forward was that there was no intention to create legal relations. In the event, the court found that since there was a unilateral offer made by the father, the now deceased father, and it was accepted by performance on the part of the daughter-in-law, the normal presumption against intention did not apply. Now, this case shows us that we have to be a bit careful when we look at all these various exceptions, because you'll notice that this was not the daughter, this was the daughter-in-law. So obviously, normally there might be more distance between the parents and the daughter or son-in-law as opposed to the parents and their children. So that might have played a role, and certainly did play a role in this judgment as well. And we'll have another case along the same lines involving a daughter-in-law. So we have to be a bit careful as to where exactly the main reasons are, but certainly here it's a combination of the fact that there was a unilateral offer, as well as the fact that the person involved was not the daughter but the daughter-in-law. Now, where a family engages in purely commercial agreements, the presumption against intention to create legal relations is also rebutted. So we see this happened in Snelling and Snelling. Here, three brothers were involved in a company, and the company wasn't doing so well, so the three brothers decided that they would put in money, their own money, into the company. So each of the brothers put in money. The brothers agreed that should any of them leave the company, they would not reclaim the money they had put in, so that would just stay in. Now, one of the brothers left and tried to claim the money he had put in, and his lawyers argued that there was no intention to create legal relations because this was simply an agreement between siblings, between the brothers. The court held that since this was an agreement which was purely commercial, it was purely to do with the business, it was not an agreement that was social or domestic in the strict sense of the word, because after all, in spite of them being brothers, what the agreement was about was a business decision. So because of that, the presumption against intention was rebutted, and there was intention to create legal relations. In other words, the Snelling brother who opted out was not able to recover his money.